Thank you, Janice, for your kind words. Hopefully you can all hear me okay. I definitely have been scribbling away through all the presentations, and I'd like to thank Victim Support NI for the opportunity to be part of today's really important event to mark European Victim of Crime Day, where we remember and recognise the victims of crime across Europe. Sean gave you a really good overview of my role, which I took up in June last year, as Janice said, having left the very distinguished role of Chief Executive of Victim Support, where I learnt a lot. You will note that my job title is Commissioner Designate, and that designate word is included because the role or the office is not yet on the statute books. So there wasn't time in the last legislation, in the last mandate, to put it into legislation. So it's hoped that whenever we get an assembly back, that will be one of the bills to go through. I'm not going to talk too much about the role, but if you do want to find out more, please feel free to contact us, we have details up on the NI Direct website. The vision of our office aligns really neatly with the contribution of today's speakers. So our vision is of a society where victims of all crime feel valued and have rights to protection, participation, support and redress. The role also requires me to monitor the experience of victims, which means hearing directly from them about their experience, and also helping to signpost victims if they have complaints, particularly about the criminal justice system. Making a complaint can be an additional burden on victims, and our complaints process can be difficult to navigate. It's not always clear whether the letdown has been on the side of maybe the police or the prosecution or the courts, so we can help with that. We're today launching an animation which encourages victims to complain if they haven't received their entitlements under the Charter, and outlines how we can help. I'm hoping that technology permitting, you'll be able to see this animation during the comfort break. So the theme of today's event is one which is of great importance to me. As Janice said, I've worked in the sector for about 20 odd years now. And so victims' rights is key, and the confidence of the public and victims in our rule of law and the criminal justice system is really the foundation that supports our societal response to crime. The evolution of criminal law, I think, has been really helpfully outlined by Michael in his presentation. That evolution led to the state replacing the victim in the legal process. So victims who previously had the responsibility of pursuing the offender in order to get justice really were relegated to the role of witness, as the state adopted the role of prosecutor on behalf of the community against which the person has offended. And that role as witness rather than victim in a case is of significant issue to victims of crime, as you've heard from Amanda and also from the quotes that were highlighted earlier. The subsequent imbalance of power then that exists between the state and the accused necessitated the development of rights for the accused, whose freedom was ultimately at stake. So it's for the state to prove the accused's guilt beyond reasonable doubt, rather than the accused having to prove their innocence. The focus, therefore, of the trial centres significantly on the accused and their rights, with the role and any rights of victims often falling to one side or effectively being lost, as Michael outlined earlier. This focus on the accused and their rights in the process that has meant that victims who are most often the most impacted by the crime are left feeling like a bystander, a witness to the event whose views may be considered by the police and prosecution, but ultimately they do not hold any veto over the decisions taken. So victims will often report feeling neglected by the system and frustrated by their lack of input. A victim I met with recently outlined how she felt that the system had complete disregard for her feelings. As is all too common, the case was adjourned numerous times for a variety of reasons. And she, despite efforts to prevent this from happening, she ended up running into the accused twice when she was attending court to give her evidence. She was particularly upset at the fact that one of the reasons for one of the adjournments was due to concerns regarding the mental health of the accused. And that led to a delay which ultimately impacted on her own mental health. Victims report issues with communication throughout the process, from lack of information regarding bail, failure to appropriately investigate, lack of updates about case progress, and often last-minute changes to when and where cases are listed. They report a lack of information sharing between agencies as well, with maybe one agency, so maybe the police not being clear as to what the prosecution are aware of, and vice versa. And also a lack of connectivity between civil and criminal proceedings, particularly in cases of domestic abuse where there's family proceedings going on. So this sense of powerlessness that many victims feel when engaging with the system often echoes the powerlessness they felt during the crime itself. The re-traumatisation and re-victimisation of the system is something which Sean alluded to in his presentation this morning. A victim described to me recently how you don't have any choice or any voice in the courtroom. She said that what happened afterwards with the trial was 10 times worse than the actual crime itself. Now, it's fair to say that certainly in the last probably 50 years, governments have responded to issues raised by victims, and Michael again sort of outlined how they've been brought back into that triangle of interests. There has been an increase in legislation to improve the information support and protection available to victims, and a recognition really of the need to address the re-victimisation that can be caused by the criminal justice system itself. And I welcome the department's recognition of that in their victim and witness strategy. For those of you from Northern Ireland, you'll be aware that the Victim Charter was placed on a statutory footing in November 2015, and that provided a minimum set of entitlements for victims of crime. And just picking up on Michael's point, you'll note that that is entitlements that we talk about in our charter and not rights, albeit they're on a statutory footing. Now, this legislation transposed the EU directive on minimum standards into our local legislation. And I remember being in victim support at the time, and it really felt like a landmark moment for victims, which aimed to improve and strengthen their rights. Over 7 years on from its implementation, I regularly meet with victims who have not heard of the Victim Charter and have not received their entitlements under it. So our Criminal Justice Inspectorate, when they looked at the treatment of victims and witnesses in 2020, reported, and I quote, "a strong sense of apathy and disconnection by many organisations providing support to victims when asked about the ongoing influence of the Charter." So the system is failing to deliver what is promised to victims and what they really should rightly expect. Far too often, their needs are an afterthought rather than being seen as an obligation enshrined in our law. This lack of implementation of the Charter really serves to me as a sobering example of how positive changes to legislation and policy are not enough in and of themselves. Any improvement to our system must be accompanied by relevant training, resourcing, monitoring and accountability frameworks to ensure that they actually achieve their intended outcome. My work, of course, hasn't stopped since the introduction of the Charter, and there has been a drive for continuous improvement in how victims and witnesses are treated, with our victim and witness strategy aiming to put victims at the centre of the process. In our last shortened mandate, we saw progress in a number of areas. So we had significant reviews into how the system deals with victims of hate crime and victims of sexual violence. Sean referred to the introduction of remote evidence centres, which allows sexual violence victims to give evidence from another location away from the courtroom. We are the first jurisdiction in the UK and Ireland to introduce sexual offence legal advisors, and I'm delighted we're going to be hearing from Peter, one of the SOLAs and victim support later. We introduced new offences to improve the tools that police can use to address offending behaviour, such as coercive control legislation, stalking, upskirting, downblousing, and non-fatal strangulation, which is due to come into force this summer. We introduced the Assist NI Advocacy Service for domestic and sexual violence. So that's adult and children, all genders. And we also made progress on an under 13 protocol, which has enabled some child sexual violence cases to be fast-tracked through the system. I think all these initiatives are to be welcomed, and they do indicate our government's willingness to address the challenges faced by victims. But it's important, however, that we continue to invest in these initiatives and ensure that the policy and practice change is effectively implemented, as well as ensuring that we appropriately monitor the impact of these changes so that we're able to evidence the so what factor. So we're able to say to victims, this is what's improved, this is what the difference is made. Unfortunately, the quality and accessibility of data regarding the victim experience is an area that I believe we're weak on in Northern Ireland, and an area I want to see improve. We must continue to explore what further rights can be afforded to increase victims' participatory rights in the process. Whilst it's clear that some victims would rather not be involved in a criminal justice process, and many, of course, do not report crime, others are calling for the opportunity to have greater engagement and visibility in how we respond to offending across society. This can include discussions regarding charges in the case, as well as how the victim personal statement can be used in court. And also we need to be further exploring the use of restorative practice and what that can bring to victims and helping address their rights and needs in the aftermath of crime. When speaking about victims' rights, I think it would be remiss of me, though, not to mention during an event like this, my grave concern regarding the progress of the UK Bill of Rights bill currently progressing through the UK Parliament. A bill which really the Joint Committee on Human Rights has stated is likely to reduce the protections currently afforded by the Human Rights Act. This view is shared by the majority of respondents to the government consultation, but does not appear to have changed the government's determination to push through. It's particularly concerning to me that many of the issues raised against this bill and its impact are raised by those organisations who represent victims of violence against women and victims of trafficking and modern slavery. Now, returning to the focus of today, one of my strategic priorities that I wanted to touch on is the right to privacy. A key priority in my strategy is to strengthen the protection governing victims' personal information. As you'll know, in order to appropriately and fairly investigate any reported crime, the police must explore all reasonable lines of inquiry in order to determine if a crime has occurred, and if so, who is responsible. Now, as part of the investigation, the police may access a range of information pertaining to the victim in the case. Now, this can include access to their mobile phone, details from GPs, social services, school records, etc. Now, this can be included in relevant information that is then passed to the prosecution when making a decision to prosecute. But it can ultimately be passed to the defence, and if not, can be actively sought by the defence by court order if it's believed that the information may assist the defence or undermine the case put forward by the prosecution. This whole process in a criminal investigation is referred to as the disclosure process. Now, given the potential sensitivity of this information, and the Article 8 right to privacy rights of the victim, there's strict legal guidance which governs the disclosure process. And that guidance is incorporated in GDPR legislation, court directions, as well as guidelines issued by the Attorney General. Some personal records may need to be obtained and shared with the defence in order to test the truth of the victim's case. But the requirement, certainly what's written down, is clear. Only those that are relevant to the facts and obtained through reasonable lines of inquiry should be shared. Victims should be informed and involved in the process, and any search for information should be proportionate and necessary. The Information Commissioner, however, in their examination of practices across the UK with regards to mobile phone data in 2021 and the disclosure of personal information in sexual assault cases in 2022, found that there was an excessive amount of data sought and without the victim being fully informed or being told what their rights were. So this ICO review led to a series of recommendations which has led to changes in legislation in England and Wales, which really is seeking to ensure that any information that is sought should be clearly necessary and proportionate. Now, I've been working with the ICO, the Prosecution Service and the PSNI on this issue, and I'm keen to ensure that where the PSNI have a lawful reason to access information, that this is clearly understood by the victim and that they understand their rights in this regard, and in particular have time to consult with a sexual offence legal advisor as part of this. Now, I probably should note when I talk about the SOLAs that this is the first jurisdiction, as I said, to introduce such a service. And whilst further legislative provision is needed to enhance the role, and there's plans to expand the role for child victims, it is, in my opinion, and as Sir John said, it's a game changer. And I think it's one of the most significant improvements for victims' rights, which has come out of the Gillen Review to date. That access to legal representation for victims is what victims are calling for. And I think it's something that we need to build on and learn from. So in examining the actual issue of disclosure when taken up post, a case came to my really across my desk in my first week, and that highlighted the issue of disclosure of counselling records or therapy notes. In the case in question, the victim had chosen to postpone counselling until her case was completed at court because she didn't want her notes to be potentially disclosed, not just to potentially the accused in the case, but even to prosecution and court officials. That decision not to access counselling meant that she waited 5 years before she could begin her therapeutic journey. I met with another victim recently who told me that the knowledge that her counselling notes could be disclosed to the court meant that she was effectively censoring herself when engaging with the counsellor. She described how she was treated, she treaded the line needing to speak about and her fear of things being documented. So that ultimately impacted on her trust and safety that she felt in what really should have been the safest of spaces. Now, I should point out to anybody who's alarmed out there, the counsellors are really alert to this issue and will normally keep really minimum amount of notes for fear that it could be disclosed in this way. But it's the fear of victims that, in my opinion, that is making victims choose between their right to effective healthcare and their rights to a criminal justice outcome. Although victims experience sexual violence in numerous and different ways, there's really strong evidence to demonstrate that it is associated with the risk of multiple forms of psychological harm. This can result in a range of negative physical and mental health outcomes, such as depression, anxiety, PTSD, substance abuse, fertility issues, eating disorders, and chronic pain. If left unaddressed, the psychological and emotional impacts felt by a victim have the potential to become chronic and more difficult to resolve as a result of early intervention, commonly in the form of counselling or therapy. That is therefore crucial to the recovery of those who have experienced sexual violence. The PPS last year released a draft policy on the prosecution of sexual offences, and it recognised that victims can be reluctant to have counselling during the criminal process for fear that their notes or records may be requested by defence. The policy states that whilst these notes and records may be requested, this shouldn't deter victims from attending counselling. The dilemma in those statements is obvious to me. The guidance simultaneously recognises that survivors' access to therapy is vital, yet in practice, counselling notes remain subject to disclosure. This dissuades many survivors from accessing therapy. The purpose of therapy is to explore feelings, not to investigate facts. To the criminal justice system, a victim's account is evidence and as such must be objective. There's no expectation on therapists to take verbatim notes in relation to victim disclosure, and the notes taken tend to really be more focused on subjective feelings rather than objective facts, unlike a police statement, which really does focus on those objective facts and are recorded for the very purpose of the court environment. But given the incompatibility between feelings expressed in a confidential private therapy session and the requirement for objective evidence in a criminal trial, it does raise the question as to why therapy notes are being used at all. Victim support agencies in Northern Ireland have reported clients will often ask during initial assessments if their records could be used against them. They'll ask if they can check their notes from previous sessions to review what they've said. Victims are effectively being forced to make a choice between health or justice. Instead of focusing on recovery and processing their experience during therapy sessions, they're remaining vigilant as to how their words could be used against them in court, or indeed worse, avoiding therapy altogether in order to pursue justice. The level of intrusion that victims experience into their private lives can cause them to drop out of the system or make a decision not to report at all. Research in England and also anecdotal evidence from victim support providers in Northern Ireland also suggests that victims feel under pressure to consent to the access of their personal data in order to ensure that a criminal trial goes ahead. We know that the prevalence of sexual crime and serious levels of underreporting has really increased the demand in Northern Ireland for the system to radically reform. The Gillen Review identified a range of weaknesses that have to be addressed, and victim withdrawal has been identified as a significant source of attrition in sexual violence cases. Recent figures show about 42% of rape cases do not proceed because of victims' withdrawal, and about 36% of sexual violence cases the same. I believe that the current practice of accessing therapy notes and the subsequent pressure that this places on victims is adding to those attrition rates. Victims should have a right to withdraw their complaint at any stage during a criminal investigation, but this should be a choice, not something that feels forced upon them because of a fear that their most vulnerable and intimate thoughts will be subject to scrutiny or interpreted in ways over which they have no control. I fully recognise that during a criminal prosecution, there are several competing interests at play. It's back to that triangle that Michael referred to. We have the defendant's fair trial rights, we have the state's interest in prosecution, and we have the victim's rights there to privacy. Undoubtedly, the disclosure of relevant material is an essential part of a fair trial and must be handled fairly, effectively, and justly by all parties. But when it comes to the disclosure of a therapist's notes, I do not believe we're striking the right balance, and that's resulting in victims choosing between healthcare or justice. Victims deserve and need the right to both. I'm therefore engaging with a range of stakeholders, including the legal professional and counselling bodies, to see if we can find a way to fairly address the legitimate Article 6 rights of the accused, while still addressing the legitimate fear of victims with regards to their Article 8 rights to privacy. How we balance these rights needs to be examined. So in conclusion, really, if we are to address the needs of victims of crime and ensure our public's confidence in our criminal justice system, we must continually listen to and amplify the voices of victims. We must take action that demonstrates our respect for victims' role in the process and recognises the harm caused to them. We must increase the rights of victims to protection, participation, support and redress. And in order to help do this, we need political leadership through a local assembly to drive forward improvements and ensure that sufficient resourcing is in place to ensure that our criminal justice system is fit for purpose. So I'd like to thank you, and I hope you enjoy the rest of this morning's event.